This podcast is sponsored by Murgatroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgatroyd.com/podcasts.
Welcome to the fourth season of Murgatroyd's Innovation Talks podcast. We're delighted you've joined us. If you have any questions, you can email us at innovation.talks@murgatroyd.com or via @Murgatroyd on Twitter. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hello, I'm Catherine Bonner, lead here at Murgatroyd's Southampton office, and I'm very pleased today to be joined by Tom Gibb.
Hi, Catherine.
Hi, Tom. Tom is patent attorney and director working alongside me at the Southampton office, and we're pleased today to bring you a podcast all about important points to consider before you launch a new product. So, Tom, we have this all the time. People come to us with new ideas, new innovations. Yes?
Yes, certainly, especially just before they're about to launch a new product.
And potentially launch at a trade fair or in trade press. We have that a lot. And there are lots of things to think about before launching a new product. There's often tooling, prototypes, a whole heap of administration to do. But please don't forget about intellectual property. That would be our message, wouldn't it?
Yes, definitely.
So first of all, can we think about protecting the product or the process, perhaps with a patent application?
Yes. So when someone comes with a new product or invention, I think the first thing I always look for is the potential for a patent application. So when considering a patent application, what you really need to make sure is that your invention hasn't already been disclosed to the public. As if your invention is in the public domain, it's no longer possible to file a patent application, at least in the UK and most other jurisdictions around the world.
So you've completely missed the boat there. Really
Definitely.
important to keep it under wraps. Okay. And we can prevent disclosures outside terms of confidence with non-disclosure agreement, keeping things perhaps vague initially if talking to suppliers or prototypers. Yes?
Yes. I think the best way of going forward is always, if possible, to keep your invention completely to yourself. Obviously, we live in the real world, and maybe there are some commercial reasons why you need to disclose at least certain aspects of it. As you say, Catherine, non-disclosure agreements are very good for protecting this, as they give you some protection in case a third party discloses the invention against your will. Other than that, as you say, keeping things vague is an option, but it's a very difficult balance between keeping your invention secret enough that you can still file a patent application while giving away enough information to interest potential commercial partners.
Yes, commercial partners, investors. Really, we'd like to have the patent application on file before any disclosure. So with a patent application, what features are we looking for there in the product?
So for a patent application, what we're really looking at are features that solve a technical problem. So functional features that solve problems that have gone beforehand or make things better.
So improvements over existing known products or processes.
Yes, certainly. Alternatively, you can look at a new process in itself. It's another subject matter for a patent application, or potentially, even if a product is known, a new use for it.
Excellent, excellent. We have a lot of, I'm thinking now, at the moment, I see a lot of computer implemented inventions and innovations. And it is important to say that although it can be difficult to secure patent protection in that area, it is not impossible. So I really would say to people to seek advice before a product launch, even if it is in that traditionally complicated area of computer implemented invention innovations.
Yeah, from my side, I do a lot of work in chemical compositions, and even your composition may differ very slightly from what's gone before. But if that slight difference in composition results in a significant technical improvement, that's certainly something we can really focus on when filing an application and successfully move an application to grant.
Excellent. And again, innovation, solving a problem, those are really good indicators that we might be able to go ahead with a patent application. And again, before launching, speak to your intellectual property advisor, come and talk to us. Really keen for people to get in touch. And the information that we need at that stage, we usually have details that we like to see are set out in an invention record form, really. But the key things I'm always looking for are what's the difference in the new innovation compared with what's gone before, and how that is affected, how it's brought to life, really.
Yes, certainly. I think it's important to say we probably need less information than you think to start drafting an application. We need what's gone on before, why yours is better, and the features that make yours better than what's gone before. Once we have that, it's very easy to put together at least a first draft of an application.
And then move on from there. And again, protection is not available until the patent application is actually on file at the UK Intellectual Property Office, where we file first. So that would be for functional features of a product. Other new product launches might, I suppose, not have a new functional element.
Certainly, I mean, a lot of very commercially valuable products aren't wholly functional. And if you want to protect the shape and appearance of a product with a registered right, then registered design applications are certainly something to look into.
Yes, and that would be for protecting the overall, we say, look, feel and character of the product. More of an aesthetic as opposed to functional aspects. I filed some really great new designs actually recently for toothbrushes.
Good.
sounds an unlikely source of innovation, but yeah, really, really great toothbrushes. And also something with a far more industrial leaning and aspect of a compressor that we've obtained registered community design rights for. So yes, any new product, there may well be registered rights available with designs. And the time limit on designs, is there any time limit there?
So designs have an advantage over patents in that you can have disclosed your new design to the public before the application is placed on file. However, it is important to make sure that any disclosure was less than 12 months before the filing date of your design application. So
that can be outside terms of confidence, disclosure ahead of filing?
Yes, although there are certain aspects, it is preferred that it remains confidential before you place the design application on file, but it is possible to file a design application even after an invention has been disclosed to the public.
Important difference there then, and a real route to protection that where you may have no option to go ahead with a patent application. Okay, great. The designs can be registered in the UK and in the European Union with an EU-wide design right. We've got a couple of podcasts on designs, which I think are very interesting and really applicable, and there'll be a link to those in the podcast notes. Other aspects and areas that people need to be aware of when launching a new product, what could we think of there?
Branding is always something that's key to look at.
Yes. And how the product is going to be presented or fit into the range that already exists. Yes. I think our trademark colleagues have something to say on branding, no doubt there. Yes, absolutely. And we work alongside our trademark colleagues quite closely for that. I always think packaging as well, there can be protectable features of new packaging that might come from a new product launch.
Yeah. On that note, I filed a patent application for the packaging itself. If you have a very clever way of packaging your product, that in itself can be a patent application. Yeah,
completely agree. Yes, packaging is often an unnoticed area of innovation. And yes, I also have filed registered designs for a way of packaging a champagne bottle, which sort of opened up and expanded on the recipient, opening a tab at the top. It's a very, very clever registered design for that. And I think also other patent applications for elements of packaging. And one of our clients is very active in the area of packaging and the experience that a user has on opening the packaging. So yes, really, really important area of innovation and area of protection. So branding and packaging, really, really important. And I suppose any website copy and any way that you're describing the product needs to be tied in, and would be a good idea to really focus on the innovation there that you have in the product to create a buzz potentially about the new product launch. And we've certainly reviewed website copy and website material before launch to tie in with new product and a new process launch.
On that note, if you're launching a new website, I think it's important to make sure you know who owns the copyright in your website and in any photographs you use on that website to promote your product.
Yes, definitely, and taking full account of that in line with any big fanfare of product launch. You would be ill-advised to go ahead without securing all the copyright images in case you had to take it down. And we have advised people who have been unfortunately in that situation, and the amending of a web page can always be a tricky process and something you don't want any downtime for your website to have. So yes, let's get it right at the outset. So
certainly.
Yes, yeah. And so overall, people need to really think about aspects of a new product that might be protectable, and to think about all of that, we would definitely say before product launch.
Definitely. Before product launch is certainly the most cost-effective time of making these considerations and will result in the best protection for your product.
Yes, the strongest rights. Completely agree with that, Tom. Yes. And thank you for your input and for chatting about this afternoon. Thank you, Tom.
Thank you, Catherine.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgatroyd.com.